Yes, student. Okay, let us continue. Let us deal now with section 80. Let us deal with section 82, right? Where section 82 deals with several charges, right? That are to be disposed by the same court. Say, for instance, a person is charged for murder, possession of firearm, and possession of ammunition. That matter will be taken to a higher court, not a district court now. I mean, we'll prepare an indictment and the person will be taken to a higher court where those charges will be disposed of. That means will be dealt with, all of them. You cannot say, no, because there was pointing of firearm, that offense must be dealt with in the district court. We cannot do that, or in the original court. If the matter has been taken to the to the higher court, so that means it has to be dealt there, disposed of in that particular court. You cannot now change and say, no, we'll bring this one to, okay, I hear that there's a noise that is disturbing us. Let us pause there. Right, let us continue, students. Then we come to section 83 of the Criminal Procedure Act. Here we'll be dealing with a situation where it is doubtful as to what the accused should be charged for. Right? In that case, you'll find that the case maybe it's assault GBH, but now there's also a possibility that it could be common assault. It now depends on the severity and what weapon was used to effect that injury. If it was just an open hand or a fist and the person was hit against the wall, but it could be doubtful whether you're going to make it assault GBH or common assault, things like that. Whether it's going to be rape or it's going to be indecent assault. So there is a doubt. So section 83 deals with that. And also the court will have to take a discretion, but as we know, preferring charges is the prerogative of the NPA, that means the prosecutor. It is not for the court to decide, but the court can assist by asking questions, which is mostly inquisitorial, but we know our courts are not inquisitorial. It can only be inquisitorial when we are dealing with bail. Okay. Okay, now let's come to section 84. Section 84 of the Criminal Procedure Act 51 of 1940. This is a very important section that every law student should understand, because there's a possibility that by next year you could be part of the aspirant prosecutor program, depending on whether you have applied. If you have applied and you will be going to write these exams, but not for you guys, for the final years. Final years will there's a possibility that they will be getting this job as aspirant prosecutors. It will only happen to you guys next year. You can only apply next year and go and do these tests and also do the interviews. Okay. Section 84. Section 84 of the Criminal Procedure Act deals with the essential elements of the charge and details place, time, and the property that was damaged or property that was stolen, the person that was offended. So you will have to state clearly in the charge sheet those essential elements of the crime. Like I've said, that you've got to have all the elements of the crime. Once there's only one element missing, then that charge is defective. Say, for instance, you don't say intentional. If it's not intentional, it can't be murder. You know, it can't be murder. Once it becomes negligent killing of a human being, we know that is something else, that is capital homicide. So you need to be very careful, and you cannot be silent. Once you are silent of an element of a crime, and the accused inspects the charge sheet in terms of section 80 of the criminal procedure, then there will be a problem that that charge won't stand, because it does not describe or fit the criteria for any person to be charged for that particular crime. And also, let us deal now with section 85 of the Criminal Procedure Act. Section 85 of the Criminal Procedure Act will be dealing with objections. The accused may be arraigned in court and be given, and the charges will be preferred against him, and then the accused may object to those charges. And there is five ways or 5 scenarios where the accused can object to the charges, right? Sometimes you might say that the charge does not comply with the provisions of the Act, right, relating to the essentials of a charge. And also you might say that the charge does not set out the essential element of the relevant offense, right? That means there is one element that is missing. Then the accused has a right to do what? To object to that charge in terms of section 85 of the Criminal Procedure Act. And also, you might say that the charge does not disclose the offense. Doesn't say, okay, I'm charged, but I don't know what I'm charged for. And I'm charged for theft, or I'm charged for trespassing, or I'm charged for indecent assault, or I'm charged for rape, for instance. So it has to disclose, the charge has to disclose an offense. Fourthly, he might say that the charge does not contain sufficient particulars of any matter alleged in the charge. But you see, in order for you to understand this perfectly, you must read section 119 and section 122, capital A of the Criminal Procedure. Then we'll see what do you mean by particulars, because sometimes person is charged and you can ask for further particulars. So, okay, we don't understand. Give us further particulars as to why are we charged with this particular offense, right? So you need to give all the particulars, like saying the time, the place, what was stolen, the color of the car that was stolen, or the color of the cow that was stolen, right? And also, the accused may object to the charge if his name, for instance, is Sipo, and on the charge sheet, the name that appears there is Bongani. So the accused may say, no, I object to this charge because this is not me. The name that you have on the charge sheet is not me. Okay, also, let us look at section 86 of the Criminal Procedure Act, right? 86 is where now the court will order that the charge against the accused be amended, right? That's what it deals with. And then let's deal with section 88. Section 88 also is very important because it deals with a defective charge, a defective charge sheet. That means there's a defect in the charge sheet, and that defect must be cured only by evidence. It doesn't say if there's a defect, it doesn't say the charge must be thrown out. It must be cured by way of evidence. Okay. And also, let's look at section 89 of the Criminal Procedure Act, right, where now we are dealing with previous conviction. And the law says the previous convictions are not to be alleged in the charge sheet. unless that previous conviction it forms part of the crime that has been committed by the accused. Say, for instance, if the accused is charged of having violated a parole condition, man was on parole and he has violated parole condition, or maybe the police came and they could not find him. So before he is taken back to jail, then he will be charged for having violated parole condition. Or let us say if you were given a suspended sentence, okay, suspended sentence, then there we have no choice but to mention that you were given a suspended sentence, that you might not be found in possession of stolen goods, and here you are again found in stolen goods, then that conviction will be alleged in your charge sheet, right? Like I said, person cannot be cross-examined on his character by the prosecutor. The same thing, because when you say this person is a habitual criminal, he's got previous conviction, that means we are now attacking the character of the accused. That we are not allowed to do. Okay, let us also deal with Section 132. Section 132 of the Criminal Procedure Act is very important, where you've got an accused before court, and the accused is admitting, is pleading guilty to the offense, and then when he is examined by the presiding officer is not satisfied, because the person is pleading guilty, but he has got conditions, no, I'm pleading guilty, but once a person says but, because when you are pleading guilty, you must plead guilty to all the elements of the crime and say that you have no defense in law against what you are being accused for. You cannot plead and say but it was not my fault, he started. You just plead guilty, simply plead guilty to the offense, and then you can be convicted. But remember, you plead guilty and get convicted. Once you've been convicted, the next chapter will be that you are being sentenced. So there is a difference between conviction and sentencing. So you must try and establish that distinction between conviction and sentencing. Okay, when we meet in class, you must tell me what do I mean by conviction and what do I mean by sentencing, because both those have different inquiries. The inquiry into conviction and inquiry to sentencing as well. Something like talking about the probation officer, or looking at the circumstances of the accused and the victims before sentencing, things like that. Okay, so the presiding officer, in terms of Section 132, once he sees that he is not satisfied with the way the accused has admitted to a crime, he can then enter a plea of not guilty. Right? He will enter a plea of not guilty until he has made an inquiry to say that the accused understands what is meant by pleading guilty. Okay, let us also deal now with Section 1655 of the Criminal Procedure Act. It only deals with that if 5 people commit a crime, those people will be arraigned in the same case, and they will be called accused number 1, accused number 2, and accused number 3, including those who were charged for accessory to a crime. What do we mean by accessory crime? That means where somebody commits a crime, maybe a crime of robbery, and you help him hide the stolen property or the stolen money, or you help him to evade justice, then you are being accessory to the fact. Then you will also be arraigned and be charged in the same trial with those guys. You will be maybe accused number 7. Remember, look at the case of Bester, Thabo Bester, that there are so many people who were involved. Some were not part of the burning of the body in the cells. Some were only contributing towards providing uniform so that he can escape from prison wearing prison uniform. So such things. That those are accomplices are people who were part of the commission of the crime, but maybe to a lesser extent, but they were part to that, they are accomplices. And also let us come to section 156, right? Section 156 of the criminal procedure. We need to read that as well, because it deals with people who have committed an offense in separate circumstances, or committed offense in a separate place, but committed at the same time or almost at the same time. For instance, if we've got people who are charged with public violence, and these people were seen blocking the road, burning tires, and some were seen on the same road, but at another place. They were stopping vehicles and burning vehicles, right? Or taking the drivers out, like what has just happened at Van Riemen. People were burning trucks, but others were burning the tarmac, because even burning the tarmac, burning the tires on the road, you are actually damaging the surface of the road, because tar burns and it has to be repaired. So that is malicious injury to property. That's another offense. If you burn vehicles, that's another offense. But as long as when the prosecutor will prove that the evidence that will be led will prove that these people had the same, what is called common purpose. Because if you burn tires on the road and you intimidate people not to go to drive past that particular road, you are actually committing the same offense but at different places with the same purpose. So it is important that we deal with that. You must read these sections that I've given to you, 155, 132, 80 to 89. You must read them, because obviously there will be a question on this. So let us end our class here for now. I hope you will find time to study what we've just started, because this is very important. Study it, because it will come out in your assessment. Definitely there will be a question on this. Thank you.